Welcome to Wilmic's Risk Management Information Podcasts. I'm Tom Watson. In this podcast, we will talk about limited scope representation, or unbundled legal services. I'm speaking with Diane Diel. Diane is a solo practitioner in Milwaukee, practicing primarily in the area of family law. Diane, what is limited scope representation, or unbundled legal services?
Tom, that is a form of representation in which the lawyer and client do not contract for general representation for the scope of the entire matter, such as a divorce, to use that example. Rather, they identify and isolate a certain component piece of the matter, in other words, one hearing compared to a series of hearings for the representation, or simply provide advice in the background or drafting documents, limited documentation. It is a form of delivery of service that is very specific to the identification between the lawyer and client of what services are asked for and required and what services can be rendered in that limited way in a way that is reasonable by the lawyer.
What are the benefits both to the lawyer and to the client?
Well, the lawyer gets work to do. The lawyer does not get a full case. The client, I think, the significant advantage really is the limitation on what the client spends, or the management of what the cost is for the client. A significant detriment for the client is that it's a little bit like looking at looking at your fingertip only when your whole hand hurts, something like that. It does not give the client the breadth of knowledge that the lawyer might have to offer.
Sounds like it can be in many ways economy driven, that the client sees this as a way to get some legal help when they might otherwise not have been able to afford, the full loaf, I guess, so to speak.
Right, and I certainly think that is the chief advantage, is that for lay people confronting litigation in what might otherwise be a self-represented fashion, or confronting any type of problem, buying a house, selling a property, engaging in defensive traffic tickets or what have you, whatever legal matter presents to the client, it does afford the opportunity to have representation one way or another.
Is this, I think it's a growing, my perception is this is a growing, maybe not phenomenon, but it's a growing practice both for lawyers and clients seeking help?
I think that it is growing. In part it's growing fairly rapidly because of recent amendments to the Supreme Court rules. In Wisconsin, in July of 2007, the Supreme Court adopted the Wisconsin version of the Ethics 2000 work from the American Bar Association, which created a greater recognition that lawyers can limit the scope of their representation, whereas previously Supreme Court Rule 1.2 provided that on consultation, lawyers and clients could limit the objectives of representation. In the new rule at 1.2c, the word used is scope, that with informed consent and where reasonable, the lawyer and client can agree to limit the scope of representation. I think that's a material change in the rule, and it gives a sanction to the kind of limitations that we're talking about here.
Do you think more clients are looking for this type of help?
I think more clients are looking for a do-it-yourself kind of universe. I think that in the day and age of what everyone is calling Web 2.0. You can look up your legal problem online. You can find significant amount of information online about the issues. You can look at a Wikipedia entry and distill knowledge and information about what you are confronting. I think that many more people think that they can avoid paying a lawyer an unlimited amount of money to represent them by taking charge and controlling their own representation. And when they run into obstacles, they have a consultation. In my view, Tom, there's nothing really unusual about limited scope representation when you think about it as a function of initial consultations with clients. Clients who don't know you will come meet with you, seek to learn who you are, what you are about, and gain information about the legal issue that confronts them. What's happening here is that we are formalizing and naming that kind of limited contact with the client.
This probably falls under the larger picture of a lawyer's role maybe in this day and age changing, evolving to some degree. It's not what it used to be.
Right. Well, I certainly think that this is a part of a larger global change, the universal change in really what the role of lawyers is now and what will be, given the internet, given the speed of contact around the universe, given, as I say, the globally available access to law in the form of statutes and cases and digests and so forth to the public. This is all a component piece of looking at the way in which legal services will be delivered in the future, and I do believe that this will be a significant part of how the public secures legal advice. Lawyers do need to become familiar with this direction that the public is going, and they need to be able to know how to manage limited scope representation in their own practice.
And you use it in your practice, and how do you use it?
I do use it. I perhaps do not use it as extensively as some, but I have for many years, of course, engaged in client consultation. I have for many years met with clients and had as the limited objective of the meeting the notion of reviewing perhaps a marital settlement agreement that has been written, asking me specifically not to become involved in the action, but to render advice about whether or not the agreement looks reasonable, livable, is it fair, things like that. I do not personally at this time take on one motion out of 5 pending in a given lawsuit in order to represent a client just on a single issue, although I'm aware that that is happening. I also experience clients who, on the other side of cases, not my client, but their former spouse who do this, who tell me, no, don't write to my lawyer about that. I'll deal with you about this one. My lawyer's only engaged for custody and placement, not for issues that are as small or in one communication from an individual the other day. Picayunish was his word. This is a picayune issue. And so I'm confronted with trying to deal with it from the other side as well.
Are there risks or is there a downside to this type of representation?
Well, there's certainly a downside that a client will identify the tree and miss the forest, and hopefully the lawyer will not miss the forest. This is where the factor in SCR 20:1.2c of reasonableness of the limitation starts to come into play. Is it fair and reasonable to only address one part of a topic that is so interwoven and mixed up with other outcomes? In family law, for example, tragically enough, child support will follow the amount of placement that a person is given. I obviously dislike that part of the law, but it is the fact, and if you only focus on one aspect, are you really able to render advice that is comprehensive enough so that the client can be governed by it?
You bring up a good point. Issues are sometimes interwoven. So how do you separate those in your limited scope representation? I guess sometimes, as you're alluding to, you just can't.
Right. Sometimes it's very difficult to do it. And in that case, I think that if the lawyer cannot reasonably secure the informed consent of the client, or if the limitation on scope is unreasonable, the lawyer is, I think, ethically obligated to decline that representation.
So would you say limited scope representation is not for everybody? I guess both from a lawyer point of view and a client point of view.
I certainly think that's true. The trick is going to be identifying which clients are the ones for whom it's not appropriate and which lawyers shouldn't undertake to do it.
And you want to make that determination early, obviously.
You do. I think that this is a situation in which working off of some kind of a checklist outline, written fee contract, so that the lawyer and the client can together and in real time look together at the services that the lawyer can offer and identify those and isolate the ones that the client is looking for specifically. Lawyers don't get to put their head in the sand if they see issues that need to be addressed. There's case law that says, for example, a lawyer rendering advice to a person about a workers' comp claim was liable for malpractice when that lawyer did not identify the fact that there might be a negligent third party that should also be pursued. So the lawyer has to know enough about the area to be able to do essentially a complete scan of the legal environment that the client presents and identify those things that are reasonable and prudent about investigations and avenues that the client needs to pursue. What
if the client wants to expand the scope of representation in the middle of a case? How do you handle that?
Well, I think that would require a careful sit-down and conversation. It would require a review and a rewriting of the representation agreement, and I certainly would think that this might be the norm. Actually, my personal theory is that clients will not understand the value of legal services in helping them decipher the universe of information that's available to them until they have a lawyer doing that for them. So I think it's really required to be very careful and rewrite the agreement and get the new agreement in a solid way, that this is an expansion.
How do you communicate limited scope representation to the opposing party or the opposing lawyer or even to the court?
Well, at this point, Wisconsin is a little bit in a beginner stage. In many states in the United States, in California, for example, there are specific court-prescribed forms that identify on a checkoff basis exactly what the nature of the representation is. I believe that Wisconsin lawyers need to be very careful. If you're engaged in litigation simply, for example, to argue the summary judgment motion after it's filed and briefed, that's what your notice of retainer filed in the court should say. And it should exempt counsel on the case from copying you in with any correspondence or pleadings filed in the court file that are extraneous to that specific motion hearing and that specific limited objective.
I can envision a situation where you go into court for a hearing in a family law matter, for example, and you deal with one issue and then the judge expects you to also handle the next issue on the docket, and it's difficult for you then to extricate yourself from that hearing because the judge basically won't let you.
Right, and the fact that you file the notice of retainer indicating that you're there for child support purposes only and something erupts over the division of personal property or something like that, the court is not necessarily bound by your notice of representation. And so I think that in Wisconsin it may well be an avenue of exploration to look at whether or not circuit court rules should be adapted, whether or not the SCR needs to be further adapted to facilitate this type of representation so that the court, the lawyer, and the client are all on the same page. Certainly work is being done in many states in this country to try and narrow the ranges of responses that happen in individual courts to that kind of situation.
I suppose this could also lend itself to opening the door to a disgruntled client down the road who is unhappy that the case didn't come out a certain way in one area, but that was not the area that they hired you to do the representation, but they blame you anyway, and then you're sort of on the hook.
Well, it's that old theory that somebody else must always be at fault, isn't it? And yes, I think that the risk is there. There's always that risk. I think that if the lawyer has properly limited their representation and made a very good written record of that limitation and advised the client of what dangers might exist, including the fact that if you don't engage me to look at the broad scope of all of the issues that could come up in this matter, that adverse consequences might flow to you, I think that the lawyer is probably protected. The question about that really comes down to the reasonableness component of the ethical rule. And my view is that if you have too much trouble defining the reasonableness of it, if it doesn't feel reasonable, don't undertake it. But generally speaking, around the country, courts have upheld and found very reasonable the limitation on scope when it's clearly articulated in documents, and have dismissed complaints by aggrieved clients that relate to matters outside of that scope of representation.
Final question, Diane, and I think you touched on this a little bit earlier, but what is the future of this type of representation? I guess given the economy and the changing ways that lawyers represent clients now, would you agree that there's a place for this in the practice?
I think this is very much the coming thing. I think if you look globally at the trends in the country and indeed in the world, limited scope is the future. In Wisconsin, there's a large movement towards divorce practice going to collaborative practice, which is a form of limited scope representation in that the lawyers represent the clients in negotiation and settlement meetings only. They do not take the case to court and are unwilling to proceed into a litigation context. The representation agreements limit the scope to settlement only, and by their terms terminate the representation when a contested matter is filed. This is a movement that is, in my view, exploding around the entire world. That type of representation manages costs and contains clients' exposure. Mediation has started to explode. Really, mediation services are another form in which limitations of scope are there. And taking those two forms of dispute resolution into consideration and looking at all of the rest of the developments in the universe in which self-help clinics and the wide array of knowledge and forms are available on the internet, I think that this is an avenue in which futurists have really proposed and hunched across many writings that this is the way that legal representation will develop in the future.
You've been listening to a Law Practice Information Podcast, a service of Wisconsin Lawyers Mutual Insurance Company. For more information about our company, visit www.wilmic.com or call 1-800-373-3839.